Welcome everyone to the Federal Bar Association Key Tam Sections, the Rounds FCA News with Tejinder Singh. The Rounds is Tejinder's regular analysis of noteworthy FCA decisions from across the land. I'm Scott Oswald, chair of the Key Tam section with Tejinder Singh, a partner at Goldstein and Russell. Tejinder, hello. It's hard to believe it's December already.
Yeah, happy holidays. Great to be here and looking through some interesting developments with you.
So let's first touch on the Supervalu case. It's something that we had reviewed in some depth in our September episode, Tejinder, and this is the case out of the Seventh Circuit where at the time there was a rehearing petition that was about to be filed. This dealt with the knowledge requirement of the FCA. So tell us, in light of the rehearing denial, what's the status of the law in the Seventh Circuit and beyond?
The Supervalu decision held that the Safeco standard applies to False Claims Act cases. And what the Safeco standard is it's if you have an objectively reasonable interpretation of an ambiguous law and you haven't been warned away from it by some authoritative guidance by the government, then you cannot be deemed to have recklessly or knowingly violated that law. Even if you thought you were violating it, even if you wanted to violate it, you can't be held liable. The knowledge standard doesn't reach you. So the pharmacy chain Supervalu had escaped liability using that standard. I actually filed the rehearing petition for the relator, and the United States filed an amicus brief in support of the petition, saying that the Seventh Circuit standard was going to really disrupt FCA enforcement. The Seventh Circuit recently denied rehearing, and so it looks like this one is going to become a cert petition, and we'll see if the Supreme Court is potentially more interested.
So what does that cert petition look like? What do you think the question presented might be?
I think the question presented will be whether merely having a reasonable interpretation of the law is enough to defeat scienter under the False Claims Act. That decision, the Seventh Circuit's decision, conflicts with a decision from the 11th Circuit, and we think it also conflicts with precedents from the 9th Circuit at least. And so there is a pretty decent argument for a circuit conflict. Now, other courts have come out in the direction that the Seventh Circuit has, including the DC Circuit. So the conflict is actually reasonably robust and might be of interest to justices.
All right, so we'll be watching for that. Let's turn to our second case, Tequila Monroe versus Fort Valley State University. This is a district court case out of the Middle District of Georgia, and it deals with when a defendant can assert 11th Amendment immunity as a defense to coverage under the False Claims Act. This is the first time we've dealt with 11th Amendment immunity before. Give us kind of an overview of 11th Amendment immunity defense that defendants can raise under the False Claims Act.
Sure. So in general, the states are immune from suit except to the extent that they have waived their immunity or the federal government has abrogated their immunity. The 11th Amendment grants them that right. And it extends both to the state itself and also to arms and organs of the state. And there's a body of case law about when an entity like a university, a public university, might be covered by 11th Amendment immunity. The standard for saying that 11th Amendment immunity has been abrogated by federal law is that there has to be some clear indication in the law of an intent to abrogate immunity. And so this case actually deals with whether the False Claims Act's retaliation provision manifests that clear intent, because the retaliation provision is not limited to persons. That is, the potential defendants aren't limited only to persons. And that means they could include states. But in order to include states, the law has to also abrogate 11th Amendment immunity.
So one of the important factors the court looked at and the test that the court applied was kind of a follow the money test, Tejinder. What's that all about?
Yeah, so part of how you figure out whether something is an arm of the state, for example, is just how is it funded and financed and who could potentially become liable for its debts. These are the obvious concerns that 11th Amendment immunity is designed to address. It's designed to stop people from taking from the public fisc of the state unless there is some waiver of that immunity. And so in determining whether an entity that is not itself the state, but is potentially an arm of the state gets the benefit of immunity, looking at how it's funded and where payments would go if it were sued, where they would come from if it were sued, is an important part of the inquiry.
And in this case, the court found the money was coming directly from the state of Georgia.
Yeah, that's correct. And also, I think so that point will be true sometimes for public universities, not true other times. Most of the time, I think for a university setting, it will be, but there'll be other organizations, research labs, hospitals for whom it might not be. The more broadly applicable point from the decision, though, is that the court holds pretty unequivocally that the retaliation provision does not contain the clear intent to abrogate immunity. So having determined that this university was part of the state, that was the end of the inquiry from there. It's just the case can't go forward because the False Claims Act does not get rid of immunity. It doesn't have the clear language necessary, even though the court acknowledged that there are strong policy arguments and points from the legislative history that one could marshal. It said, you really need clear evidence here and you don't have it.
Let's turn to our third case, which is U.S. Ex rel. Foreman versus AECOM. It's out of the Second Circuit in November. And this is a case where the Second Circuit reversed because the district court improperly relied on material outside of the complaint to grant the defendant's motion to dismiss. But there's a really interesting discussion about whether the Supreme Court's Escobar materiality requirement applies to express false claims. What's your read on this?
Yeah, so this is a decision where technically the relator wins, but the opinion is one that I think defendants would probably have more reason to celebrate. If you look at the discussion of materiality, so the relator made a few arguments. This was about a defense contract where the defendant had supposedly inflated the number of hours its staff worked and had fudged the records about how much its staff were working in order to inflate the amount that the government paid. And the defendant itself had calculated that it had received about $140 million in improper payments as a result of this conduct. And so you would naturally think, like, that sounds pretty material, right? You have $1 billion contract with $140 million of improper payment. That sounds material to me, especially when you look at the statutory definition of materiality, which says, does it have a tendency to influence what the government paid? Here, the defendant argued, though, that the government knew about the issues and paid nevertheless, and that under the Escobar decision, that gets the defendant off the hook. And so the Second Circuit engaged in a bit of weighing here to try and figure this out. The threshold issue, though, was, does materiality even matter in cases involving factually false claims? That is, where you say we worked 10 hours, but you only worked 8. Does it matter in cases involving express false certification? Or does it only matter in the implied false certification category of cases, which is what the court directly considered in Escobar? And here the Second Circuit says it's a requirement in every kind of case. And what I think is strange about that is I get why it has to be a requirement in an implied certification case. If the gist of the argument is, hey, your claim is false, not because you told a lie, but because you implicitly said you complied with every condition of payment or with every important law, the fact that the law is important, that it's material, is woven right into the falsity. It has to be there, or you can't have a claim. I think it's also probably right to say that for an express false certification claim, if you say I complied with these laws, it's got to be material, because otherwise the court gave this hypothetical in Escobar where it said, well, what if the government requires you to expressly certify that you complied with the entire US code, right? Well, imagine that hypothetical. If that were true, then I think it would be fair to say, well, if you expressly certify you comply with the entire US code, but you didn't comply with some immaterial, irrelevant law, no big deal. Your claim's not false, right? So I think even in the express context, it makes sense to talk about materiality. But when you have a factually false claim, I honestly don't get it. Because if you say I worked 10 hours and you only worked 8, you don't need to look into whether that misrepresentation is important to know that it's false. It's false no matter what. And that's really what materiality is getting to in the other context. It's how you understand falsity. And so the Second Circuit here says, no, it applies across the board. But I think that's a pretty questionable decision, and one that's actually in the teeth of prior Second Circuit precedent.
So this really dovetails into the new legislation that initially was offered by Senator Grassley back in July. You covered that, Tejinder, in one of our episodes this summer, and has now been reported out of the Judiciary Committee. But there's some big changes here, right?
There really are. Some of the changes are encouraging and some of the changes are concerning. So the most encouraging change when the bill was reported out of committee on November 16th is that the language about materiality has been fixed. Previously, there was this odd burden shifting framework introduced that I thought really couldn't work because it required the plaintiff and the defendant to prove and disprove the exact same proposition, but according to different standards, and it was a hash. Now, the new version of the bill says, in determining materiality, the decision of the government to forego a refund or pay a claim despite actual knowledge of fraud or falsity shall not be considered dispositive if other reasons exist for the decision of the government with respect to such refund or payment. And that's pretty much a codification of what most circuits are doing with Escobar. So you have this AECOM case that we were just talking about as a good example, where the defendant says, hey, the government knew, but it continued to pay. And this statute takes that head on and says, no, that's not dispositive if there's some other reason why the government might have continued to pay under the contract. That's what most circuits have been holding, but a few outlier courts were still getting it wrong. And it's good to see that Congress taking an interest in that and trying to clarify and bring uniformity to that proposition of law. On the more concerning end, the old version of the statute, the original version of the amendment, said it was going to apply to all cases, both pending and prospectively. Now it only applies prospectively. And the problem with that is that it could lead to this odd inference that the law, as proposed in the amendment, is not the law right now, right? If the amendment is necessary to change the law, then it means the law was doing something different before. And so it actually might, in the many circuits that are currently getting materiality mostly right, it might actually cause them to reconsider that for pending cases. It might cause them to veer onto the precise path Congress is trying to avoid. And so I think that's a real concern, and it's something that I would kind of hope Congress addresses or talks about at least as the bill continues to move. There are other amendments too. One of them is about the standard for government dismissals, and one is about whether the retaliation provision applies to former as well as current employees. That's the subject of a pending cert petition, and so if this amendment passes, it will probably render that petition moot. So there's a lot to see, and I think it looks like this bill is now moving. So there's reason to think there may be legislative change on the horizon.
So Tejinder, we are going to be watching these amendments as they move through the Senate in the new year. Thank you. And thanks to each of you for tuning in to this edition of The Rounds with Tejinder Singh. See you next time.